How can you maintain financial privacy about what you own and how? We live in a very public world where your information can be sold to the highest bidder with a click of a mouse. Join me to explore a variety of estate and financial planning strategies, including LLCs, trusts, and partnerships to protect your privacy. Hi, this is Jim Cunningham, and we're going to talk about financial privacy strategies in estate planning. So this is a very big topic for many of our clients. Have you ever Googled yourself? Well, if your name is John Smith and you live in Los Angeles, there's probably a lot of John Smiths. But, if your name is Pinky Tuscadero and you live in a small town, Monona, Iowa, there probably aren't two of you. So, it depends on the uniqueness of your name. But it is really amazing how much information is out there in the ether. It's kind of mind-blowing in a lot of respects. But when it comes to privacy, you do have a choice. You do have some options to keep the identity of your assets a little bit private. And we have our next webinar here, and there's a QR code if you want to hit that. Our next webinar is estate planning if you don't have children. And one of the attorneys in our firm, Daniel Van Slyke, great lawyer, he will be presenting on that. And that has its own unique challenges. So I'm the partner and CEO. I'm a partner and CEO at Cunningham Legal. I've got over 25 years experience. I think when it's over 25, you just say it's over 25. We have offices in Northern and Southern California, as well as the capital region, and we do serve clients in other states. I'm a certified specialist in estate planning, trust, and probate law, a real estate broker and insurance and securities licensed, as well as a pilot. And these are the members of our team here at Cunningham Legal, the lawyers, and all we are kind of devoted to is helping you get peace of mind and creating more intergenerational wealth and helping you through that process. And this is very important. This is a disclaimer. So we're going to get started here with the content, but this is not a do-it-yourself project. You don't want to go watch this and go out and do a bunch of stuff. So this is not legal advice. There's no attorney-client connection that's being made. This is strictly information only. So let's talk about financial privacy. And what I've done is I really want to distill it down and keep this simple because it's a very broad topic. Something you need to understand is there are sources of public information that are hardwired in our American society. They're baked in, and there's really not a whole lot you can do to change the system, if you will, right? That's based on laws. It's based on government process. And one of the things that we're going to cover is the Grantor-Grantee Index. And if you go, I don't know what that is, we're going to cover that. It's called chain of title. We're also going to cover living trusts. Now, living trusts I put those up as semi-public documents or semi-private documents. There's a public aspect as well as a private aspect, as well as the court records, especially probate court records. And we'll get into that. And there are some approaches and some tools. And essentially the tools are use of trusts. And we'll explain how those work and how those might be different than a living trust, as well as the corporate forms of LLCs, partnerships, and corporations. So what is the Grantor-Grantee Index and why is it so public and why should you care? So there are two methods of tracking ownership of property. So if you buy a piece of property in the United States, the high probability, and this is the way California is, there's a high probability that it's part of what is called a Grantor-Grantee Index. Now, these are records that are maintained in perpetuity. So it tracks who the grantor, and another word to think about that is seller, right? When a grantor conveys property to a grantee, which is the buyer, that's a conveyance of real property. And now that person is in the chain of title. So what that means is that person's name appears in a record and it is permanent. And this goes back hundreds of years because setting aside indigenous people who were here before and during the arrival of people from other parts of the world, when you look at title, okay, most title in the United States comes from one of just a few sources. It's the United States government, right? A lot of times the United States government initially is the beginning owner of the property and might have deeded it or granted it or given whatever parcels of property to people. But you really can trace it back to the monarchs of England. And today, of course, and just recently, I found out that Queen Elizabeth II passed away, and that's a big change for the people in Britain, and frankly for a lot of people throughout the world. But a lot of land was originally owned by the monarchs of England, Spain, France, Hawaii, right? Hawaii had a monarchy, Russia, because we have Alaska, and the Dutch Republic. You can think of Manhattan. So there were a lot of a lot of original owners, if you will, of property. And so when Owen, who's the owner, and in law school, they use O for owner and A for the first person to get title. Owen sells Greenacre, which is just a made up name. It's a piece of property, sells Greenacre to Abel. This transaction is in the public record at the county recorder's office forever. It never goes away. And in California, we go back to 1850 when we had we inherited the system of land ownership from Mexico, who inherited it from Spain. But if you look at title on a lot of properties, it does go back to the King of Spain. And that's really the source of title, or the Republic of Mexico. It goes back. So the point I'm getting at here, this goes back hundreds of years. Okay, this is not something that's going to change. Once a deed is recorded, it cannot be unrecorded. You cannot pull the cream out of the coffee, as it were. Once it's recorded, once your name appears in the chain of title, it's not coming off. It's going to be there forever. Now, why do we have public disclosure of ownership? Because we want property to be freely transferable from one person to another, and we want to enforce property rights. So people have a right to know, this property that I'm buying, does this person who's selling it, and can I be guaranteed that they own the property? And then can I guarantee that I continue to own the property and it cannot be stolen from me? Yes, there's a component of title insurance, but the Grantor-Grantee index on a high level is your friend. It does have this public component. And I think this is probably the hardest thing to keep private is ownership of real estate, quite frankly. So let's say, how does this work? When you have a living trust, let's say Abel creates the Abel Trust, and the trust buys Greenacre. Now, the world sees on the Grantor-Grantee index, Abel, trustee of the Abel Trust, dated, happens to be today, September 8th, 2022. And that is in what is called the chain of title. So you can think of a chain with links, and one chain is linked to another, one link is linked to another, and it makes a chain. That is the chain of title for this particular parcel of property, which is Greenacre. Now, bank accounts, investment accounts, and other assets that are transferred to the trust remain private. And I'm going to put an asterisk on there. They are not publicly available in the same way that title to property is available, right? However, if you Google yourself, or if you go to what is called a skip tracer, that's someone who does an asset search, those people oftentimes have access to those as well. We're not really going to cover that here. That's kind of next level privacy, but what we're going to hit here, the big one is real estate. So your IRAs, your 401ks, and life insurance, those stay out of your living trust. So those really shouldn't even go into your living trust. And Abel's ownership of Greenacre is a matter of public record. Again, it's a matter of record forever. Now, I do want to dispel a couple of common naming assumption myths. Okay, there's one big one. A lot of people think, well, I just won't use my own name, right? Because we talked about the Abel Trust dated September 8th, 2022. I'm not going to use my own name. I'll just make up a name for the trust, which you can do. Now, that's really not how it's done. Now, I know some attorneys do that. We do that for some clients, but it doesn't really avoid the problem of Abel appearing in the chain of title. It only delays it. So here's the example. When Abel buys Greenacre, Abel requires the grantor. All right, the person. So when Abel's buying this property, Greenacre, he's going to require the grantor of the property to vest title as XYZ Trust, dated September 8th, 2022. So it's not connected to his name, not even Greenacre. It's just XYZ Trust. Okay, not Abel, trustee of XYZ Trust. And so what you're seeing is when you do have to at some point put the name of the trustee, because a human with a heartbeat who's alive is going to have to pick up a pen, not a pencil, before a notary and sign a document. That document gets recorded at the county recorder's office, and it has to be a human being. So Abel will appear in the chain of title. Now, granted, if Abel's selling the property, so what I'm talking about here is not him buying the property, but when Abel sells the property, his name will appear in the name of in the chain of title, and so his name is still public. So I would say using a name other than your own individual name is essentially privacy light. But I will tell you, in the real world, when you convey property, when Owen conveys the property to Abel, you do have to have a human being's name on there. You do have to, in the chain of title, have the name of an individual who has authority to act on behalf of the trust. If it's Abel's trust, Abel is going to have to be named at some point in the recordation process at the county recorder in order to later convey title. So and setting aside financing, we'll cover that a little bit. So again, the problem with omitting the name of the trustee in the title is at some point it will pop in there. Well, can't Abel simply name Baker as trustee? So let's say Abel says, you know what, I'm going to name Baker as trustee, my friend Baker, my best friend, Baker, trustee of the XYZ trust. The problem with that is Baker then becomes the trustee of the whole trust. Okay, the whole thing. So what about Abel's bank accounts and stocks and mutual funds? Well, Baker ostensibly would be the trustee of that. Now, can you do a separate living trust that only holds your real property? Yeah, but there's actually a better way to do that, which is in that vein. So before we get there, though, subscribe to our YouTube channel. So this is a great opportunity to hit the subscribe button. This will pop up in your feed and you'll stay informed. So this is something I call the private living trust. Now, what is a private living trust, Jim? This is kind of interesting because you just said trusts are public. So Abel goes out and to a lawyer and creates a trust called the Abel Trustee of the Abel Trust dated September 8, 2022. Abel then also creates a separate trust and calls it Baker Trustee of the Greenacre Trust. Now, why would we have a trust? Why would we have two trusts? Okay. That Baker Trust or that Greenacre Trust is going to hold the assets it's going to hold assets in trust for another trust. Now, this may sound kind of weird. You can think of it, Taco Bell has the chalupa. It's like a pizza and a layer of a taco shell and all this other stuff. It's kind of adding another layer on there. All right. So this is like the chalupa of estate planning. So here's what's going on is instead of Abel taking title to Greenacre as Abel trustee of Abel's trust, Baker, trustee of the Greenacre Trust, buys the property. Okay. So Baker is the one buying the property. Baker holds just that asset, just that property, Greenacre, in trust for Abel's trust, and Abel is the trustee of that trust. So what this does is that removes evidence of the ownership of this property from the public Grantor-Grantee index. This is a very common strategy that famous people use. Okay, it's a little bit of a hack in the sense that if you're wondering how very famous people hold property, this is one way they do it. Maybe it's called a straw man, whatever it is, but you can have another person hold the title. And these trusts are not long trusts. All the trust says is Baker's holding property in trust for Abel, trustee of the Abel Trust, so that when the property is sold or whatever happens, Abel's going to need to be part of that process in escrow, but will not appear in the chain of title. So again, the true owner of Greenacre is not a matter of public record, and you have this frankly, this kind of a shell of a trust. This is not an asset protection strategy. Really, this is a privacy issue. So if you don't want, if you're a well-known person and you don't want people to know that you own this certain piece of property and you might be in there, if you're like your health or your life or your safety is at risk, that's kind of important. We do have in our firm people with varying degrees of fame. And it's interesting because we'll have clients come in, they say, hey, I got this role in this film or this television series. And now people are like showing up at my house at night trying to video me while I'm making dinner. Right. So this is a real issue for some people. And if that's you, we can certainly help you out with that. So the other thing that's really important is the private living trust retains Prop 13 protection. And we're going to talk about an alternate strategy using an LLC. That's more problematic. But this retains your Prop 13 protection because the assessor's required to disregard trusts and look through trusts to determine the identity of who the real owner is, what we call the beneficial owner. So you can have a trust layered with another trust, and the assessor is going to look through those trusts. If you have an entity structure, they cannot look through the entity structure. It's a different approach. So again, this is used by famous people. Again, there's an alternative approach, which is an LLC. But if you're going to get mortgage financing on this, it may be a little tricky. It's more specialty financing potentially, but again, it is keeping the true ownership of the property out of the public record. So Anita asked Jim, what might be an example on why someone would name their trust different? You may have answered just now, but clearly some reasons. Well, some people just don't want, if somebody has a very distinctive last name and you type that name in, you can quickly pull up ownership records. And I think people are just concerned about being a target, an unfair target for lawsuits and being taken advantage of. Okay. So what about, this is a little euphemistic. When there's no plan in place, or there is a plan and behind closed doors, lawyers talk about this, the elder is uncooperative. Now, what do I mean by that? I mean somebody who is maybe with declining cognitive health, and they really should not be handling their own affairs, but they insist on handling their own affairs. I've been diagnosed with advanced dementia, but I want to handle everything on my own. I'm not going to let anyone help me. Even though you have an estate plan, a court can still step in and frankly take over. So that's what I mean by an elder being uncooperative. So what happens? And this really kind of this gets a lot worse, just to warn you. What happens if you're substantially unable to provide for your own food, clothing, or shelter, or you're substantially unable to resist fraud, duress, menace, or undue influence? Those are the two standards for a conservatorship of the estate or a conservatorship of the person in California, a conservatorship. Now, in other states, it's called a guardianship. So if I've got advanced dementia, my wife comes in, if I'm not being, compliant and I'm being uncooperative, my wife comes in and essentially has a court remove my name from all those assets. And you get a court order to do that. Now that is a conservatorship. This is a public proceeding. A conservatorship is a public proceeding with mandatory disclosure of really sensitive financial information to anyone who might have a remote interest in the outcome, which is typically going to be your children or other descendants. Potentially siblings if you don't have children, and the accounting. So whenever there's a conservatorship of the estate, so if the court appoints another person to take over your finances, there is a mandatory accounting, and that becomes part of the public record. And a lot of people don't realize this. All of your assets become public record. Anyone can check it out. Now, there are some mechanisms that you can go through to make a motion before the court to keep things private, but by and large, these things are, if they're not publicly available, they're available to people in your family. And these are people that you may not want to have access. You may not want to have them know what you have because you're a private person. You don't want your grandkids knowing that you're a multimillionaire because they'll continually hit you up for money, whatever the case may be. So this is a process that does reveal all of your assets. Now, without a plan in place, when you pass away, with no living trust in place, this is even if you have a will, no living trust, your estate goes through probate. Very public disclosure of assets. You have a third-party court referee who's appointed by the governor and serves for a term. A court-appointed probate referee values all your assets. They kind of count the pennies on your eyes, if you will. Mandatory court notices. You have a publication requirement in a court saying that you passed away. When the hearing is, you can walk up to any court counter and ask for a copy of the file. You can even ask for them to reproduce the file so that you have full and complete copies. So, and I will tell you, people in various professions, realtors, people who lend money to get, if somebody says, I can't wait the 2 years for a probate, I want to get my inheritance now and get in advance. There's a whole netherworld out there of people that are out there looking at these public records. So it's not that these are kind of hidden in plain sight. People actually do look at these records and they do target the people who are going to inherit. And some of the people who are inheriting, frankly, may not be that responsible and, are going to pay 40 cents on the dollar to get their money a year or two quicker. So, and again, this lasted a couple of years. Now, this probate process can be avoided with proper planning, but not the publicity. So I'm saying it's sort of avoided with a living trust. So something to understand with your living trust, it is far more private than the public probate process because there's no mandatory public filing. However, there's a big however, California Probate Code section 16061.7. Yes, that's a real code section. It's a lot of numbers in there. Does put an affirmative obligation on your successor trustee. Now, this is kind of like your executor of your living trust. So you set up a living trust and you name, one of your kids as successor trustee. That child has to notify everyone who's named in the trust, every successor trustee, every beneficiary, and anyone who's entitled to inherit. And that person also has an affirmative obligation to notify people who are disinherited. So if you're disinheriting a child, you're disinheriting a grandchild, whatever the case may be, that trustee has to make that notification. And I will say, as a little sidebar here, this is one problem with doing an amendment to your trust. So when you change your trust, you can amend the trust, meaning you have a trust that's 70 pages long, and you say, I want to change one paragraph. So instead of doing a new 70-page document, you say, I'm going to do a one-page document. Well, it's two with the notary acknowledgement, and I'm going to take away that $10,000 gift to somebody. if you have that trust, that 70-page trust and a 2-page amendment that takes away a $10,000 gift to somebody, your successor trustee has to notify the person who was originally going to get the $10,000 in the 70-page document, but now is not getting the $10,000 in the 2-page document. And they're going to know that they were in and now they're out. Okay. If you do a restatement of trust, it's where you throw away the 70-page document, use the same name, but what you're doing is you're amending all the terms of the trust. There is no affirmative obligation to send the prior 70-page document, just the new 70-page document. Well, maybe it's 75 pages because of inflation, right? So there's no affirmative obligation to inform this person who was going to get 10,000 that they were going to get it, and now there's an amendment where they don't get it. So instead of amending your trust, in that case, you should consider looking at a full restatement of trust. Now, there's some other reasons why you may not want to do that, depending on age, infirmity, and a variety of factors, and that's something you certainly want to talk to your lawyer about. So I would say that on a high level, trusts can be viewed as semi-private planning tools. Okay. Now, what about inheritances? Let's say we get through probate, we get through the public process of probate, or we get through the semi-public process of trust administration. Trust administration is what we do when somebody who set up the trust stops being trustee, whether through incapacity or death or resignation. So let's say a living trust keeps an inheritance out of probate. Well, when the person inherits, what happens then? Now, we call these in our firm the Inheritance Protection Trust, the Dole It Out Trust, or the Special Needs Trust. And that's in my book, Savvy Estate Planning, What You Need to Know Before You Hire the Right Lawyer. I would encourage you to go to our website to check that out. An Inheritance Protection Trust, what does that do? Well, that protects the inheritance that somebody receives. So an Inheritance Protection Trust, and we cover this in a lot of our videos on YouTube, an Inheritance Protection Trust says, look, I'm going to leave the share for Johnny, okay, in a trust where it is protected from Johnny's creditors. It's protected from Johnny's potential future divorce. Maybe it stays in Johnny's estate when he dies, or maybe it's outside of Johnny's estate when he dies, depending on your wealth level. And that may save death taxes when Johnny dies. So this is very long thinking. It requires kind of a shift in thinking to multi-generational thinking. But the Inheritance Protection Trust is designed to not only protect the inheritance, but it also keeps it private, because that Inheritance Protection Trust actually gets its own taxpayer identification number. It's a very important point. So if somebody has your Social Security number and they want to do skip trace, if those accounts are in another taxpayer identification number, it is less likely to appear in a skip trace and less likely to be found. And I'm not saying this to, for people to weasel out of obligations, but there are a lot of predators out there. There are a lot of people, if you have money, there are a lot of people who are trying to scam you. There are a lot of people who are trying to come after you. And this is one way to maintain privacy. Again, if you value privacy, you should be thinking about this. Now, the Inheritance Protection Trust is for a competent, fully functioning adult who's not going to blow it. The Dole It Out Trust is for someone, who may be a spendthrift, right? They may be spending the money. They may not have experience with money. That's just another thing. If you leave $1 million to somebody and they've only ever earned $3,000 in a month, that $1 million is going to seem like an infinite amount of money. And you and I know that it is a finite amount of money. And you typically don't find that out until it goes to zero. Somebody said once, I was rich, then all of a sudden I was poor. The account went to zero, right? And then the Special Needs Trust, we've covered a lot of materials on that. And Daniel actually has done a webinar on that as well. The Special Needs Trust, which is doing planning for somebody who has needs, a loved one who has needs-based public assistance benefits. So these are people typically on SSI. So with the Inheritance Protection Trust, the Dole It Out Trust, or the Special Needs Trust, assets can be protected in a continuing trust with a separate taxpayer identification number, which is really kind of cool, right? It's its own like Social Security number for the trust, and keeps it out of the public records, keeps it out of the chain of title, right? If you're not the trustee of this individual trust, maybe someone else is the trustee, and you inherit a vacation home in Tahoe, your names might not even be on that trust, but it's still your house. So we do have a question here. I want to answer that. Anita asks, if a current trustee wants the successor trustee to give a copy of the trust to all children of the person that passed, should the trust be amended or what? Okay, well, here's what happens. The great question, Anita. When somebody dies, a copy of that trust, a notice is required to be sent to the person saying that they have the opportunity to see the trust, a complete copy of the trust or whatever's relevant to them. most attorneys will just send it to the person because they have 4 months to challenge the trust. And if the day before that 4 months is up, they say, oh, I want to see the trust, they get another 60 days. So you might as well just send it out. But great question. All right. What are some workarounds? Let's talk about LLCs, partnerships, or corporate ownership. Now, I will tell you, we covered this in another webinar that's on our YouTube page. Most people who buy real estate now are buying it typically in an LLC or holding it in an LLC, or and that is taxed either as a disregarded entity or a partnership. So that's kind of the modern way of holding title. And the reason is, if it's held as a partnership, you get an adjusted cost basis at death. You do not get that if it's in a corporation or it's an LLC taxed as a corporation. That's a topic for another day. But the example here we'll use is Greenacre LLC. So Owen, who's the owner of Greenacre, conveys Greenacre LLC to Abel. And now Abel owns the shares of Greenacre, so Abel's name does not appear in the chain of title. Now, unlike a trust, it doesn't say Owen conveys Greenacre to Abel, manager of Greenacre. It just says Owen conveys Greenacre to Greenacre LLC. Okay, so Abel's name does not appear in the chain of title, and the ownership of, at least not currently in California, the ownership of the shares of the LLC is not a matter of public record. Bear in mind, though, that every state and the District of Columbia do have registration requirements of varying degrees, okay, for disclosure of who the managers are. Some states require it, some states don't. Some states require you to provide other information that other states don't. So every state's different. We've got 50 experiments plus DC, so 51 experiments in the United States. I would say the single biggest mistake, if you want to have a, hey, Jim, what should I not do? The single biggest mistake is people naming themselves something called the agent for service of process. Now, before you panic, this is not a permanent record. In California, the agent for service of process, if you file a new statement of information, and we'll get to that in a little bit, if you file a new statement of information, that erases the prior ones. Okay, so California has just updated their website on this year on that. So here's what an agent for service of process is, and here's why you need it. Every state requires you to have an agent for service of process. What is that? Well, when Abel creates Greenacre LLC, if somebody wants to sue Greenacre LLC, they need to know where to serve the court papers. Okay, it has to be a street address, not a PO box. It has to be a street address located in the state where you're filing that form. So if you file a California LLC, you have to appoint a California agent for service of process. Many people appoint themselves, and guess what address they put on there? Their home address. You can see the big mistake there. If Abel's trying to stay, not have his name in the public record, he's just blown it by appointing himself as the agent for service of process. So there are third parties and our firm is a registered agent for service of process. And there are corporations and entities that register with the state so that for a fee, right? For a fee, Abel can pay a registered agent for service of process. So Abel's name does not appear on the service of process. The other thing to bear in mind is this is not a do-it-yourself project. If Abel goes on the state's website and for $70, you can create an LLC. If he creates the LLC, he will be forever known as the organizer of the LLC. So his name will be associated with that LLC. Our clients hire us so that our name, our firm's name, is on the paperwork for the individual that set up the trust, right? So Abel comes to us and says, hey, I'm going to set up Greenacre LLC. We set that up. We name our firm as agent for service of process. Abel's name never appears on anything, okay? Not at the state, not on the county level. Naming yourself identifies that you are connected with the entity and gives you less privacy. So Anonymous asked, did the IRS a couple months ago change the deadline for filing Form 706? Yes, for portability. If doing so solely for portability purposes, that one has 5 years from the first spouse's death to file. That's correct. If the first spouse passed in 2022, which is this year, and the 90-year-old plus survivor has a $6 million estate comprised primarily of single-family rentals, is there any reason to file portability 706 now versus waiting perhaps 4 years? If the surviving spouse passed during those years, it seems that portability filing would be, in essence, be combined with the 706 for estate purposes. and one would file with the subsequent passing of the surviving spouse. Okay, let me unpack this for you, Anonymous. Any lawyer, given those facts, any lawyer who knows anything about this is going to say, absolutely file your portability return within the current limitation period. I wouldn't count that 5 years. And I don't, it's interesting you raise this because this is an open question. This is the, and I don't know the answer to this. Is it 5 years forever? Or is it, 5 years and that 5 year time period somehow expires going forward? I don't know the answer to that question. I would not wait for a totally different reason. When you file the portability 706, frankly, you have to value property. You've indicated that these are rental properties, that these are residential properties. You're going to want to get a contemporaneous valuation, meaning if somebody passed away this year, you're going to want to get a valuation of what are those properties worth this year. People ask me, Jim, can I get a BPO, a broker's opinion of value? Can I get a BOV or a broker's professional opinion, or do I need to go for like the full Monty and get the full appraisal? I'm going to tell you as a lawyer, get the appraisal. You can use the probate referee, and sometimes that's less. But when you're talking $6 million, if you have to spend, I don't know, $20,000 to potentially save millions of dollars, not only in capital gains taxes, but death taxes, that is an investment that I would make every day I could possibly make it, $10,000 or 20 or whatever the number happens to be. By the time you add up the legal fees and the valuation and all of those things, I'm giving you kind of a big number. I think it's worth it. And I would not wait. I think it's a bad idea to wait because first of all, that law can change, that rule can change, right? The government can give it and they can take it away. And if somebody passed away in 2022, our standing advice, if there is a surviving spouse with a $6 million estate, absolutely file your portability election, because in 2026, the amount you can leave tax-free drops to $6 million. What do you think is going to happen to the value of those properties in 2026? It's going to be higher than it is now. So I think absolutely file for portability. It also depends on what the trust says. So, but again, this is something you can just reach out to our firm, and my law partner, Rochelle Lee Warner, is in charge of trust administration. You can talk to her. You can talk to maybe one of the associate attorneys, but I think their advice will probably be what I'm telling you as well. So, what are some workarounds? So California requires a statement of information to be filed with the California Secretary of State for every corporate entity, LLC, or corporation, if you're doing business in California, or with managers, officers, or partners who are California residents. So this is very important. If you're a California resident and you are managing an LLC, you have to register that LLC in California. Now, some people don't do this. California will catch up one day with that because they're vigilant on this. The minimum franchise tax is $800. The maximum is, I think, $11,970, something like that. That's if you have 5 million in revenue. Don't mess around with this. Stay compliant. If you do not stay compliant, you are putting at risk the asset protection features of entities. Okay, that's very, very important. If I'm a judge and you haven't registered with California, and you should have, guess what? You're probably going to have a lot less protection than if you had actually registered with the state. So again, the statement of information requires public disclosure, but you can always amend your statement of information. And I believe it used to be that the prior statements of information were on there. I believe they've revamped their website and now it's just the most current. I believe that's the case. And this is a very recent change. So what is the workaround? And I mentioned this, when Abel's lawyer, not Abel, because if Abel creates the LLC, if he creates Greenacre LLC, his name's going to be in the system, right? Forever. Abel names Charlie as manager of the LLC. Abel owns 100% of the LLC. And the California LLC buys Greenacre. So Charlie's the manager. Charlie registers the LLC. So for the whole world can see that Charlie's the manager of Greenacre LLC, even though Abel owns 100% of the shares. And that is, I think, probably one of the, I don't want to say easiest, but least, the lowest hurdle to get over to maintain some modicum of privacy. Okay. Now, in what instance would you not want to use a California LLC? Now, when we have real property in California, we typically have a California LLC, but the next question is who owns the shares of that LLC? A lot of our clients, though, they do create a Wyoming LLC, and they create a very special type of Wyoming LLC that was created in the early 1990s. is a Wyoming close LLC. And I want to walk you through this because this is very important. And many of our clients choose to use Wyoming as a jurisdiction. I personally think it's better than other jurisdictions. So something to understand is Wyoming does not require you to identify the manager of an LLC. California does, Wyoming does not. So Abel can have the Wyoming LLC, but he's not required to have a public filing where Abel is the manager of the Wyoming LLC. So very important distinction. Again, California residents must register a Wyoming LLC in California and disclose the identity of the manager. So if Abel says, well, I'll just register it in Wyoming and ignore California, you're running the risk that you're not going to have the protections afforded by the statutes we're going to talk about, especially if it's real property. So Abel creates a Wyoming close LLC. So he contacts our firm. Abel has never been to Wyoming. You don't have to go to Wyoming. He contacts our firm. We set up a Wyoming close LLC holding some of Abel's assets, stocks, bonds, mutual funds. He names Charlie as manager, who's a California resident. So we had to register the Wyoming LLC in California. And Charlie names Abel as agent of the manager. Now, agency authority means that Abel can bind the Charlie, the principal. So Abel is able to sign on behalf of the entity, but is not a public filing. Okay, this is all legit stuff. This isn't like crazy, sneaky stuff. Abel's still paying his taxes. Charlie's still registering the LLC. But what we're doing is we're creating a system where Abel's name is not in the public domain. So if you're a famous person and you're like, how can I manage my stuff and without a business manager for whatever reason, how can I manage my stuff but not have people know the identity of my entities, right? I'm gonna maintain my privacy. You can go ahead and set up a Wyoming close LLC and name even a trust company you can name as manager, who in turn can appoint you as an agent. So why not just use a California LLC in that instance? Because California does not require you to identify the manager. It also does not identify the beneficial owners or managers and does not report information to the IRS. Now, California may or may not share information. It's kind of their call, but Wyoming does not share information with the IRS. Again, this is not nefarious purposes. This is, people have to pay their taxes. Wyoming's privacy, I believe, and many other experts believe, far exceeds that of Nevada, Delaware, and New Mexico, because they do not have close LLCs. Now, why is the close LLC such a great thing? Outside creditors cannot break into your LLC to satisfy a judgment. So if you owe money outside of the LLC, right, not inside of the LLC, if you owe money outside of the LLC, those creditors cannot come in and say, hey, give me money that is in the LLC. The sole remedy the creditor has is the charging order. What a charging order is the charging order says whenever money is distributed from the LLC on these shares, that money has to go to the creditor. Well, if you don't distribute the assets, the creditor, because the Wyoming LLC that's taxed as a partnership does not pay taxes, okay, that tax liability passes through to the creditor. So the creditor has a tax bill but does not have the money to pay the taxes. So it's kind of a poison pill. That is a charging order. That's why a lot of people use Wyoming LLCs, because it really enhances, the bottom line is it enhances your negotiating ability with a creditor. If the creditor says, look, I'm going to sue you and take those assets in your LLC, you can say, well, good luck, because you're not going to get the assets, you're going to get the tax bill. And so you're at a bit of a standoff, and then you're able to negotiate a more fair or settlement for yourself as the owner of the shares of the LLC. And Wyoming is the only jurisdiction in the United States that treats single member and multi-member LLCs the same. So a single member LLC, if I create a Wyoming LLC and I put $100,000 in there and I own 100% of the shares, that is a single member LLC. There's one member. That is considered a disregarded entity. I report whatever income on my federal return, and I'm not filing a separate federal income tax return for the Wyoming LLC. Anita says, I'm not clear. If all assets are held in California, can you file an LLC in Wyoming for all your California assets? Yes, you can pick whatever jurisdiction you want. If you have a living trust, you don't have to pick California as your jurisdiction. It's a free country. I could pick Nevada. I could pick South Dakota for many of our clients, when we set up dynasty trusts, we pick a jurisdiction. We do not pick California because the maximum term of a trust in California is 90 years. In Nevada, it's 360 years. So you can use different states, you can use different jurisdictions that hold assets in California. Now, if that sounds weird to you, Apple is organized under the laws of the state of Delaware. They're a California-based company, but they use the laws of Delaware for their corporate governance. So this is very common in the law to use jurisdictions from other states. So we've covered a lot in a short period of time. If you have any questions, we're kind of coming to the end of the substantive portion of our time together here. Remember the Grantor-Grantee index when it comes to real property. Once your name is in the Grantor-Grantee index, once it's in the chain of title, and you remember blockchain, we did a webinar on blockchain. That's permanent. Chain of title, permanent, kind of same kind of thing. Living trust is a semi-public document or semi-private document, however you want to view it. The court records, especially probate court records are really tough. It's almost like a bankruptcy. They lay it all out. These are all the assets that someone had when they passed away. This is the identity of all the people and their address. This is the identity and the address. And a lot of times there's a date of birth on the will. It's really easy to find these people, okay? And ways to keep your name out of the public record include trusts, LLCs, corporations, and partnerships. We have offices in Northern and Southern California and the Capital Region as well. Subscribe to our YouTube channel. Don't miss out on any upcoming information. And by subscribing, what you're doing is this pops up in your feed. And so you see our weekly webinars when we post them. And if you're enjoying our webinars, please go on to Google and give us a good review. If you have any questions, you can reach us at 866-988-3956 or CunninghamLegal.com. And we have next week, estate planning for people without children, and that will be with Daniel Van Slyke. And so it looks like we have no further questions. It was a pleasure spending time with you, and we look forward to seeing you soon.